Notice of probable violation, we refer to it as NOPV. Before you get an NOPV, typically you'll have an inspection by a DOT enforcement officer. They'll come in, they'll review your operations. They might ask questions. Typical things they're going to look for is training records, ensuring all the hazmat employees are trained. They're going to look at shipping papers. They'll look at how you're packaging the products, how you're doing the hazard communication, all of that. That inspection, it could be an hour, it could be days, depending on the extent of your operation. Once that occurs, then there's what's called an exit briefing. So an exit briefing will list probable violations. And it's important to say probable violations because they're alleged. They're not actual violations at this point. You look at those violations and you have a chance to refute it. When the inspector's there, a lot of times you can take corrective actions right on the spot, and that might satisfy the inspector where he won't have any probable violations listed in his exit briefing. But if he does, and we have the exit briefing, just be aware that signing that is not admitting to any violations. It's just acknowledging that he has some probable violations. You need to work with him to address those. And that's the best way to do it. So if you have an exit briefing, there's probable violations listed, work with the inspector, be open, show that you're sincere and committed to safety, and be responsive, more responsive, showing you really care, showing them that you're going to fix anything. When I was at PHMSA and I was in charge of the enforcement office, my motto was find problems and fix them. It wasn't about trying to issue huge penalties, but it's changing behaviors. And a lot of companies that cooperate, work with the inspector, doing that is going to lower the probability of having a big substantial fine or even criminal penalties. So really important to cooperate, work with them in fixing problems, investing it, even if there's some cost to it. Definitely keep track of those costs because that shows that you're really committed to the safety issues at whatever cost it is. And that works out best. Once the exit briefing is done, the inspector will go back to his office, talk to his supervisors. They'll make a decision based on, circumstances, what corrective actions you've implemented, how cooperative you are, and determine whether a notice of probable violation should be issued. In that case, it gets a little more serious, and you typically have 30 days to respond to the NOPV and showing what corrective actions you're going to take, explain why these violations occurred in the first place. A lot of times they'll take into account size of your business. Small businesses get treated somewhat differently, the economic impacts of such violations and such. But just be aware that just because you get an NOPV, it's not the end of the day. You still have time to respond to that. That's one of the things that Hazmat Safety Consulting does very well in helping clients respond to the NOPV. We get involved as soon as we're contacted, even at the exit briefing stage, which is probably best because then we can really take appropriate actions to work with the agency to ensure that whatever violations occurred and whatever potential penalties are going to be issued, that we can mitigate some of that. So then we respond to the NOPV. The agency gets back to us. They may agree that penalty should be reduced, or they might just say, okay, this is the penalty. We're taking some of these issues into consideration. We're going to assess you with X penalty. That's still not the end of the day because then you have other options for requesting a hearing. You can have an informal hearing. You can appeal to the administrator. You can ask for administrative law judge to be involved. So there's lots to do there. And it's important that you realize that people like Hazmat Safety Consulting could be very helpful in navigating through the courses of action that you need to take in any time that you get an NOPV or that you're under the scrutiny of DOT because of violations that have occurred. Once an enforcement action begins, typically the inspector is going to ask for documentation. He's going to ask for your training records. He probably did during the inspection. He's going to look at your standard operating procedures. He's going to look at what corrective actions you put in place. It's important when the inspection occurs to ensure that you document everything that the inspector is asking for, everything that was provided to him, because that's going to be useful when you're addressing the potential notice of probable violation and how you interact with the agency. It's important to be responsive, to be cooperating with the inspector. All of that is going to be beneficial in the long run to reducing the penalty or potentially not having a penalty at all. DOT also has authority to issue a warning letter, which doesn't go against your record as having a violation. It's just a warning letter. That's probably one of the best outcomes you could have. Second would be a ticket. So it's a reduced penalty process. They just assess a penalty according to the penalty guidelines. You can actually go into 49 CFR Part 107 under the enforcement section, and all the penalty guidelines are all laid out there, so that DOT uses that when they're assessing what the penalty should be. For instance, failure to indicate a UN number on a shipping paper, you'll have a proposed penalty for that, or an undeclared shipment. That's going to be, a higher penalty. But all of those penalty guidelines are right in the regulations, easy to follow. Cooperating with the DOT, working with them, providing them any documentation, any data that they're requesting. It's a process. Having the right folks to help you through that process definitely will facilitate the process and reduce the likelihood of significant penalties.